Okay, hello, John Dove here from the Advocacy Club. And tonight, our members have been performing the closing speech. So I'm just going to share some feedback in relation to the closing speech. If you're watching on YouTube, you might see I've got my tabs on. It's because I did a little exhibition for our members and decided to put some fancy dress on for the occasion. So the closing speech itself. Now, with regard to the closing speech, whenever you're preparing for a trial, and particularly, if you're given an example of a mock trial, think about your closing speech at the start, because this is the most important piece of advocacy you will conduct during the trial. This is your final opportunity to put the case together and seek to persuade the tribunal, whether it's a bench or a judge in the magistrate's court, or a jury in the Crown Court, or professional tribunal in or other areas of law. This is your chance to persuade them. So when you start preparing your brief, think about the closing speech at that point. And you can even start drafting your closing speech at that time. So what you hope to achieve from the trial, think about that and start drafting the closing speech on that basis. And that will then very much guide you when it comes to your preparation for examination of witnesses. So when it comes to cross-examination of the witnesses for the other side, you will be thinking about what points you need to put to them, what points you want to try and expose during cross-examination, and how that will ultimately feed into your closing speech. Now, within the closing speech itself, as I say, this is your chance to be persuasive. And this is your chance to highlight and shine a certain light on the evidence in the way it's being presented. And ultimately, this is your chance to comment upon the evidence. So don't just repeat what's been said by the witnesses. Don't just repeat the fact that somebody's been inconsistent. Comment upon that and explain to the tribunal why that's important, how that feeds into your case, and how ultimately that means that you should win the trial. So, if a witness has been inconsistent on a point, explain why that's relevant. Is it that ultimately they may well be lying? That could be the case. Provide that commentary. You're well within your rights to comment upon the evidence. When it comes to preparing your closing speech as well, there's nothing wrong with writing out a closing speech in full, literally word for word if you want, if you find that helpful. Because ultimately, as you go through and you type it out, you're thinking about the evidence and you're thinking about how you're actually going to present that during your closing speech. And the other side to that is to practice. Because if you practice several times, now you might find that in reality, you don't get very many opportunities to practice. You might have 2 or 3 run-throughs of the speech, but at least by doing so, you think about how that comes across, and you might chop and change certain things. You might think, oh, do you know what? I've repeated that too many times. This part should come out, etc. So really practice it. And if possible, practice in front of other people, so family members. And if they're not lawyers, particularly if you're in a criminal case, even better. Because when you're presenting to a jury, you're presenting to a panel of non-lawyers. So if you can present to, a family member, mum, dad, brother, sister, children, whatever, and if it makes sense to them as a non-lawyer and they think, do you know what? Yeah, you've got a persuasive case, then ultimately it should be persuasive to a jury member who is, in theory, not legally trained. So it's really important to practice. Certain features that I like within closing speeches include, for example, a rhetorical question. So once again, coming back, and I repeat this all the time, commentary on the evidence, commenting upon it. When doing so, you can ask a rhetorical question. You can say, members of the jury, you may think, or you might want to question, does this make sense? Or why did the witness act in this way? And then you can go on and answer that question. So if a witness has done something that, just seems nonsensical, why has this witness acted that way? The reality is because they were lying, they didn't do it, whatever it might be. But a rhetorical question is a really good feature. It gets the jury thinking about your case. It's a really good way to try and underline any of the points that don't quite make sense in your opponent's case. The thing with the closing speech as well is this is your one and only opportunity really to be really, really engaging with a presentation. Of course, with most forms of legal presentation, you don't want to be boring and switch your tribunal off, but you can really be a lot more theatrical, I think, with the closing speech. and particularly if you're presenting to a jury as well. So the key thing is don't be drab, don't be monotone, be dynamic, change the pitch and the pace, change the sentence structure, a few short, snappy sentences, some longer sentences, keep it interesting and keep it engaging. The last thing you want is a jury member falling asleep or being absolutely bored to tears by your argument, because they're not listening to you then, and you're going to find it very, very difficult to persuade them. In terms of the language as well, you want to be sort of guiding your tribunal to find in favor of your clients. So you might want to use phrases like, you may think that, you may find that, rather than you will find that. For these reasons, you will find this person not guilty. Once you're telling somebody what you're going to do, it's almost like a challenge for them. So you want to sort of guide them in that way. So you guide them along the road and say, in light of X, Y, and Z, you may feel that. And then it feels more like they're thinking, oh yeah, do you know what? When I put those things together, that is the logical conclusion. I do come to that answer, rather than feeling like they're being told what to do or what to think. And, sometimes common imagery can be quite important. So metaphors and things like that. So there's a chap in my chambers who says he quite often uses this metaphor in his closing speech. And he says he supports a football team, I can't remember which. And he says he might be sat in the away stand and there's something that happens the other end of the pitch. And all the fans on his side think it's a penalty. And so straight away, he'll shout up and say, yeah, it's a penalty, it's a penalty. Even though he's not seeing it, he's just following what everyone else thinks. And he says to the members of the jury, you can't think that way. Don't just follow the crowd. Use your logic, look at the evidence and make your own decision, rather than just trying to come up with an answer that you think is right, sort of thing, following what other people are saying. I've probably butchered the analogy he's given there, because I'm not really a big football fan, but you get the point. You can use analogies, you can use metaphors, and use sort of common imagery. Whenever you've got any weaknesses in your case, so for example, if a witness, your own witness might have been inconsistent on a point, for example, or there might be something that goes against you, then address it. Because if you don't, the tribunal, they've heard all the evidence, they've heard the weak parts and the damning parts, they're going to be thinking about it. So the closing speech is your chance to take the sting out and maybe highlight some weaknesses in your opponent's case that outweigh whatever's happened there. So deal with it. Don't just leave it, because your tribunal will notice that. And then finally, in relation to particularly criminal cases, mention the burden and standard of proof, because it's important. That's what your case is weighed against. So particularly if you're defending, I like to address this twice. I like to, at the very start, particularly if I'm defending, remind the jury that my client has absolutely nothing to prove, and it's the Crown that has to prove everything. And then at the end, remind them of the burden and standard of proof, and conclude sort of how the evidence weighs against that burden and standard, and how it may well not have been discharged by the Crown. So they're just some tips in relation to the closing speech, and I hope you found that helpful.